Good morning to all of you. Welcome to my professional ethics class. Friends, yesterday I told you regarding section 35 of the Advocates Act. You all know that section 35 deals with the powers of the disciplinary committee regarding the activities of the black sheep. So please remember, if you do any misconduct, definitely they are there to take action against you. According to section 35, on receipt of a complaint from anybody or suo motu that a person has been guilty of professional misconduct or other misconduct also, professional misconduct as well as other misconduct, the matter will be referred to the disciplinary committee. Disciplinary committee is formed as per section 9 of the Advocates Act. They will query as per section 42, I believe, 42, as per section 42. That is following the procedure envisaged in the CPC, like issuing summons, taking evidence on both, issuing commissions, issuing documents, report from the documents, all these things they follow just like CPC, and as well as the principles of natural justice. And after completing the inquiry, they will recommend. What do they? Number one, reprimand the advocate. మంచి మనిషికి ఒక మాట చెప్తుంటా కదా, reprimand the advocate, then suspend the advocate for certain time or remove him from the roles. If the complaint is false, they can drop further action. They can dismiss the complaint and they can file the same. So this is the power of section 35, right? So basically, the word misconduct has not been defined anywhere in the Advocates Act 1961. But still, you have to know what is misconduct. Basically, you have to know what is conduct. Conduct means the way you have to behave, the way you have to conduct yourself in a class, the way you have to behave as an advocate, as a professional. So if you do not behave in a proper way, then it is called misconduct. Misconduct is otherwise called as dishonorable conduct by the advocate, disgraceful conduct by the advocate, not worthy conduct by the advocate, or not accepted behavior by the advocate. So this is the misconduct. Even though it is not defined, any advocate misbehaving, he will be taken to task under the heading of the so-called section 35. That's why section 35, so the persons who are conducting the disciplinary committee inquiry, they are called as domestic tribunals. So the inquiry committee can be called as domestic tribunals. As per section 9, the Bar Council of a state, they will constitute the disciplinary committees. So they have the statutory authority to hold the disciplinary provisions. What is the aim? The primary aim of section 35 is to see that to give punishment to an advocate for the breach of the professional rules. And if it is thought to be unfit for the profession, temporarily or permanently, he can be removed. So please remember, it is an inter-department or inter-professional control. So please remember. And section 48, you have to remember, according to section 48, any legal intervention, any intervention of the court is totally bad. Only disciplinary committee, only bar council, they are competent. You cannot file a civil case. You cannot go to the consumer court. So section 48 says that the other indemnity, it gives indemnity against legal proceedings in any other court except the Supreme Court, right? So already I told the powers of the disciplinary committee are summoning and enforcing the attendance of any person, examining on oath, requiring discovery or production of documents, then receiving evidence on affidavits under 139 CPC, requisitioning any public record from any public office, issuing commissions for the examination of witnesses, and any other matter. And here an important section is there, section 36B. If the disciplinary committee cannot complete the inquiry within 1 year against any advocate for the professional misconduct, the matter automatically goes to the Bar Council of India. 1 year time is given for concluding the inquiry. If you don't do it, the Bar Council of India will take up the matter. Okay. Now, if the bar council, you are not satisfied with the decision of the bar council of a state, yes, definitely you have got a provision to appeal to the bar council of India under section 37 within 60 days. Still, if you did not get the justice required, according to section 38, you can tap the doors of the Honorable Supreme Court of India within 60 days. So, if you want to prefer an appeal, so first one is Bar Council of India, second one is the Supreme Court of India. So, please remember, sometimes, please remember, so section 44 also is important. So, the Bar Council can review its own judgment, can review its own order. You know what is review? Have a relook into the same, right? Section 43 enables the Bar Council of in state or India to make order as to cost. You may be knowing cost will be ordered maybe as compensation, maybe for fixes or false petitions, all these things. So in this connection, please read the case law of M.V. Veerbhadra Rao versus Tek Chand, 1985. Please remember. So this advocate forged, he has affixed signature on forged document intentionally. But the disciplinary committee, two disciplinary committees, they were lenient. The state level and Bar Council of India also, they took a lenient view and imposed, of course, only punishment of a very less nature. But the Supreme Court took it very seriously and suspended Mr. Veerbhadra Rao for 5 years. So please remember, court also will be looking into the disciplinary matters. In this connection, I want to tell you, the Supreme Court of India, as a court of record, they can take up the misbehavior, misconduct, either Advocates Act or, please remember, contempt also. Some cases can be taken as contempt also, right? So, to prevent the so-called misconduct, they have framed the rules. What are the rules? We are going to discuss. There are 52 rules we are going to discuss in the next video. For this time, I am concluding. Thank you very much.